She also needs to step out. Oh, I'm sorry. That's Sierra's mom. Sorry. No. I'm not. Sierra, I'm going to have you raise your right hand for me. Do you solemnly swear or affirm that the testimony that you shall give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your name?
Sierra Stewart.
And Sierra, I've seen Sierra spelled several different ways, but out of abundance of caution, can you spell it for me?
Ciera.
And Sierra, the purpose of calling you today, this is not the trial, but I want to ask you, do you know a young lady by the name of Anitra-Gunn?
Yes.
And how did you know her?
We was best friends.
How long did you, well, tell me when you first meet her.
I think it was probably my sophomore year in college.
Sophomore year of college? All right, and about what year were you a sophomore at college?
I'm sorry, I can't remember.
It's okay. When Anitra, back in February 14th of 2020, when she had disappeared, how long had the two of you been close friends?
About a year.
And would you talk to Anitra on a semi-regular basis?
Every day.
Did you talk to her about personal things that were going on with you? Is that a yes?
Yeah.
I know what a head shake is. It's just this lady's taking a test, okay? So I'm just going to say out loud, all right? And would Anitra talk to you about personal things that were going on with her?
Yeah.
Would you and Anitra talk about dating and who you might be dating at the time?
Yeah.
In fact, did you and Anitra actually live together for a period of time? Where did you live together?
In apartments. We didn't move into the house.
Okay, the house on Church Street?
Yes.
So you actually lived in that house with her for a period of time?
Yes.
Did you move out of that house before February 2020?
Yes.
Okay. Despite moving out of the house, did you and Anitra continue to be friends and continue to talk to each other?
Yes.
Would you see each other?
Yes. Sometimes. Yeah.
All right. And did you guys even work at some of the same locations?
Yes.
And over the course of your time with Anitra, did she have conversations with you regarding a person by the name of DeMarcus Little?
Yes.
And did she talk to you about the nature of her relationship with him?
Yes.
Were those private conversations between the two of you?
Sorry. Yes.
And did Anitra have other friends that were kind of in a group with you?
Yes.
You know the name Gloria Plumber or Lala?
Yes.
India King?
Yes.
Veronica Taulton?
Yes.
And when Anitra would talk to you about DeMarcus, did you express your opinion regarding DeMarcus?
Yes.
And despite you, let me ask you this, as she was telling you about her relationship with DeMarcus, did your opinion regarding DeMarcus become negative?
Sometimes.
And despite that, would she still talk to you about DeMarcus?
Yes.
I don't have any further questions with regards to this particular issue here.
Do you have any questions?
Yes, Your Honor.
Okay.
Ms. Stewart, you said that you have been friends with Ms. Gunn for a year, is that correct?
Yes.
All right, so you knew her in April 2019?
I can't remember the time period. But it's still within about a year.
You have been friends with her for a year, is that what you testified to? All right. Did she ever tell you that she was being harassed by an individual by the name of Brian Williams?
Yes.
She did? And she told you that he was harassing her to the extent that she had to go and report that harassment to the police, is that right?
Yes.
Okay. Now, did she ever tell you that she reported around April of 2019, DeMarcus Little for harassing?
I can't remember the time period.
You can't remember the time period. Okay, but you do remember her telling you that the individual she reported to the police was a person by the name of Brian Williams, right? Okay, that's all I have, Judge.
All right, anything further?
No, Your Honor.
All right, you can step down now. All right, call your next witness.
Thank you. State call Plumber. Ms. Plummer. My hand's so white. Good morning, Ms. Plummer. If you could please raise your right hand. Do you solemnly swear or affirm that the testimony that you shall give to this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. Can you state your name?
Gloria, Plumber.
L'Oreal. All right, I keep pronouncing it L'Oreal. And do you kind of go by a nickname?
Yes, ma'am.
What's that?
Mama.
La.
Ms. Plummer, how do you spell your first name?
Laurelelle.
All right, and Plumber is Plummer?
Plumbe.
Okay, like a plumber in your home?
Yes, ma'am.
All right, go ahead.
Ms. Plummer, this is not the testimony for the trial. I'm just narrowing down the issue if we could. Did you know a person by the name of anitra-gunn?
Yes, ma'am.
And how did you know her?
We were really good friends.
She disappeared in February of 2020. How long did you know her before her disappearance?
Well, we went to rival high schools in Atlanta, Georgia. She went to Westlake High School and I went to Tri-Cities High School. But we really didn't form a solid relationship until we both attended Fort Valley State University.
And when do you remember the two of you kind of coming together as friends? You said when you started to attend Fort Valley. So she disappears in February of 2020. Can you give me a year as to when you guys started becoming friends?
2017.
2017, all right. And from 2017 until her disappearance in 2020, did you remain friends?
Yes, ma'am.
Would you talk to each other?
Every day.
Would you text with each other?
Every day.
And both being students there at Fort Valley, would you see each other?
All the time. We stayed right like in 30 seconds away from each other.
As good friends for 2 and more years, did you ever talk to Ms. Gunn about people that you might be dating?
Yes.
Did Ms. Gunn ever talk to you about people that she was dating?
Yes.
And did she ever talk to you about DeMarcus Little?
All the time.
And did she talk about good things that were going on with DeMarcus Little?
Yes.
And would she talk about bad things that were going on with DeMarcus Little?
Yes.
And did you and she have kind of a circle of friends, or were you aware of other friends that she had?
Yes.
All right, let me ask you some names. India King?
Yes.
All right. Sierra Stewart?
Yes.
All right. And Veronica Taulton?
I don't know if I remember.
Okay.
I know the other two.
All right. Did you ever work at some of the same locations as Anitra?
No.
Okay. What kind of work did you do when you're in school?
I worked at a gas station. I worked at Circle K. In Byron, Georgia. I worked at McDonald's. I worked at Captain D's. And I was the general manager at Taco Bell for that.
And would you guys socialize with each other, go out to parties with each other?
All the time. Yes.
And you ever hang out at her place?
Yes.
She ever hang out at your place?
Yes.
And as women are apt to do, to sit there and talk about the men in your life? I don't have any other questions.
All right, Mr. Davis?
All right, thank you. Ms. Plum, it's true, is it not, that you had never known Ms. Gunn and Mr. Little to get into a physical fight?
No, that's not true.
That's not true?
No.
And you didn't tell that to, you didn't tell that to Ms. Nunez, Christian Nunez of the GBI on April 20th, 2020?
I can't remember.
You don't remember whether or not you told her that you didn't know Gunn and Little to physically fight?
No, that was what, 2 years ago.
That was 2 years ago. You can't remember that as you sit here today, correct?
Correct.
All right, well, if I showed you, right, a copy of the report, could you take a look at anything that would refresh your recollection
Yes, sir.
as to what you told the officer?
Yes, sir.
All right. And I don't want you to read it, but I just want you to take a look at it and tell me if that refreshes your recollection.
Yes, sir. At the time. Yes, sir.
Does that, well, first of all, does that refresh your recollection?
Yes, sir.
All right. Did you tell the officer that you had never known Gunn and Little to get in a physical fight?
Yes, sir.
All right. You then went on to tell the officer that you didn't like Little, right?
Yes, sir.
All right. And then did you ever say to her that you had hung out personally with Miss Gunn and Mr. Little and everything went okay? And this was in October 2019.
Yes, sir.
Okay, all right. That's all the questions I have.
All right, anything further?
No, Your Honor.
Okay, you can step down. All right, call your next witness.
Thank you, Veronica Taulton. Ms. Taulton, come on down this way. Ms. Taulton, I'm going to have you raise your right hand. Do you solemnly swear or affirm that the testimony that you shall give to this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you tell us your name?
Veronica.
Okay, Veronica, spell your first name for me.
Veronica.
All right, and your last name?
Taulton. Talton.
Thank you. That's just for our court reporter to make sure she knows how to spell your name, okay? Ms. Taulton, do you know a young lady by the name of Anitra-Gunn?
Yes, ma'am, I do.
And how did you know her?
I met her through Sierra.
Sierra Stewart?
Yes, ma'am.
And so Anitra disappeared in February of 2020. How long did you know her before she disappeared?
Probably about 2 years.
2 years?
Yes, ma'am.
And during that 2 years, did you guys work together?
We did. Yes, ma'am.
All right. And during that 2 years, did you guys kind of socialize with each other?
Yes, ma'am.
And would you talk to each other?
Yes, ma'am.
Would you text with each other?
Here and there.
Okay. See each other's social media?
Yes, ma'am.
And would you describe yourself as friends?
Yes, ma'am.
And over those 2 years, did you ever talk to Anitra as a friend about the men you were dating in your life?
Not really.
Did she ever talk to you about the men?
Yes.
And did she talk to you about having a relationship with a man by the name of DeMarcus Little?
Yes.
And did she talk to you about good things that were going on with DeMarcus?
No.
Did she talk to you about bad things that were going on with DeMarcus?
Yes.
And she did that in the course of y'all's relationship as friends?
Yes.
No further questions?
All right, Mr. Davis.
How you doing, Ms. Taulton?
Great.
All right, do you remember giving an interview to a GBI agent by the last name of Nunez
Yes.
on April 15, 2020? Okay. And do you recall telling her anything that Ms. Gunn told you that Mr. Little did to her? I'm not saying what someone else said Ms. Gunn said they said, but do you recall telling her anything that Ms. Gunn told you directly that Mr. Little did to her?
I don't recall.
You don't recall? Okay. And you also remember telling the agent that you had never met Mr. Little, is that correct?
I never met him.
All right. You're also friends with an individual named Stewart, right?
Yes.
Okay. All right. And at one point, you did tell the agent that Scoop had proclaimed his innocence to you, right?
Yes.
All right. That's all I have, Judge.
All right, anything further?
No, Your
All
Honor.
right, you can step down. Any further witnesses?
No, Your Honor.
Okay, any argument?
Thank you. Your Honor, under 807, and I know the court is familiar with 807 and certainly in anticipation of this hearing, but so that the record is clear, a statement not specifically covered by any law but having an equivalent circumstantial guaranteeiness of trustworthiness shall not be excluded by the hearsay rule. If the court determines that the statement is offered as a material fact, the statement is more probative on the point for which it is offered than any other evidence which the proponent can prove with reasonable efforts. And the general purpose of the rules of evidence in the interest of justice will be served by the omissions of the statement of evidence. The purpose of this hearing was to establish that the trustworthiness was present to overcome an objection as to hearsay, and to establish the nature of the relationships between the individuals and that statements were made. I will go through the case law. I'm sure that the court has had access to that, but Both the Supreme Court and the Court of Appeals have ruled on this even just recently. In Matthews versus the state, which is a May 17th, 2021 case, the state made sufficient showing of trustworthiness to admit the victim's statements under, they actually refer to it as the necessity exception to the hearsay rule, but it is 807. In that case, I have copies for counsel. We've held that a statement is trustworthy when made to someone with whom the declarant enjoys a close personal relationship.
Are you talking about 311 Georgia 531?
Yes, Your Honor. And do you have that?
I do, and that case specifically applies former 24-3-1 and makes it clear that it's because Matthews was tried before January 1st, 2013.
Right, but I thought that concerning the trustworthiness aspect, which is the same language that ends up coming up in some of the other cases, Your Honor, with regards to that, this is the long-standing provision in Georgia law.
I agree with you that that was a provision that was long-standing for a lot of years, but I also believe that the law makes clear that it is improper to cite or use those cases in cases that occurred after January 1st, 2013. You may disagree with me, but
I will move on to that, Your Honor. There was, it's the language of the using the word trustworthiness, that same language then shows up in Rawls versus the state, which is October 19th, 2020. Statements made to a victim made to a friend, cousin, and or sister about the defendant's prior abuse had sufficient guarantees of trustworthiness to be admissible under the residual hearsay exception. And in that, the testimony was material as evidence of the nature of the relationship between the appellant and the victim that sheds light on the, and then they put the word appellant, the defendant's motive in committing the offenses charged. The testimony was relevant to help the jury understand why he might have used violence against the victim. That the close relationship of each of these witnesses who she gave the statements to about the abuse experiencing from her boyfriend had the sufficient guaranteedness of trustworthiness to be admissible under 807. And I have a copy of that report that we have Rawls.
all right, I'll take it.
Okay, thank you.
I may or may not have it.
All right. The next case that I would cite, Your Honor, is Taylor versus the state, which is a 2020 case, February 10th of 2020. It's a Supreme Court case 308, Georgia 57. In that case, again, it's a murder case. The state made sufficient showing of trustworthiness as required for the admission of the victim's sister's testimony and evidence hearsay.
That case deals with the old necessity exception, but it
apologize.
says that it's instructive here. I'll agree with you that that language does say it's instructive here. I guess the biggest concern I have with what the state has just put up is you've offered no evidence regarding prong 2, which the statement is more probative on the point for which is offered than any other evidence which the proponent can procure through reasonable efforts. So I guess the question is there any other source for this information?
The statements given by anitra-gunn with regards to the nature of the relationship, there can't be because anitra-gunn isn't here. If anitra-gunn was here, anitra-gunn would testify, I told this friend and I told that friend and I told this friend. Well, anitra-gunn's not here. So the regular statements that she made to close personal friends about the ongoing nature of the relationship with the defendant it's the only way we can get those statements in. There is nothing else. We don't have any text messages between Anitra and these individual friends that we could do, no written communication. This is with regards to Anitra statements to Sierra Stewart. That's the only way we can get it in is through Sierra Stewart. Anitra-gunn statements through to Plumber. The only way we can get them in is through Plumber. Anitra statements to Veronica Taulton. The only way we can get those statements in are through Veronica Taulton. Now, I don't think that 807 says, well, you have other evidence of domestic violence, so therefore you don't need to get these statements in. The issue is regarding the specific evidence that the state is seeking to get from the individual witnesses. And in this case, We're talking about the relationship between anitra-gunn and DeMarcus Little as it's described to Sierra Stewart by anitra-gunn. Anitra-gunn isn't here to tell that story, so we have to use Sierra Stewart to tell that for us. The same way with Plumber and Veronica Taulton. Now, there is other evidence. We have the defendant's own statements, his text messages, his threats of violence, his threats of shooting up things, and his version of those events. But the events as described by anitra-gunn can only come through those who she talked to. Now, we have communication directly between anitra-gunn and the defendant, which will shed light on this particular situation. But again, how anitra-gunn perceived her relationship, how anitra-gunn perceived DeMarcus Little and the threat that he was, how she would go back and forth in that relationship, where she would be with him and then explain to her friends about why she would remain in the relationship, that can only come in through those particular statements. There is no other evidence to that and her state of mind during the course of this relationship. And I think the court pointed out that really, the nature of the relationships is there. Under the case law and the statute, it's there. These were close personal friends who knew her for an extended period of time, who communicated with her about intimate issues, who spent time with her, and the trustworthiness guarantee, I believe, is present. The interest of justice demanded in the sense that anitra-gunn is not here. And her statements and her concerns and her description of her relationship with DeMarcus Little is necessary in this particular case. And then the court's question as to whether or not there's other evidence for which the state could have procured. There are no other witnesses to those particular statements, because the other part of those conversations is no longer with us. So the state's position is that the conversations themselves are evidence. There is no other evidence that's more probative of those conversations than those conversations. And the state of mind of anitra-gunn, while remaining with DeMarcus Little despite the threats of violence, which are laid out in communications that we can establish, and other threats that were not laid out in those communications, where she would talk about he said this or he said that during telephone conversations. So these individuals are witnesses to anitra-gunn's state of mind, and there is no other evidence as to that.
All right, Mr. Davis.
Judge, first, there were no statements introduced through any of the witnesses that Ms. Gunn allegedly stated. The only thing that the state presented to the court is that Ms. Gunn knew, and then I guess it's left up to interpretation how well she knew some of the witnesses that were put up, because first of all, Ms. Taulton stated she had never made any statements regarding, at least to Christian Nunez, regarding Mr. Little and threats he made. Ms. Stewart was essentially impeached when she testified. So we're talking about indicia of reliability and trustworthiness. She had to be shown essentially the police report before she would admit that anitra-gunn never talked about Mr. Little being physically violent, and that when the occasion in which she hung out with both of them, her experience was that there was no incident of domestic violence. So even if the court were inclined to side with the state, what statements would we be admitting? Because they didn't present any evidence of a statement that was made. And 807 specifically talks about statements. So when the prosecutor made her presentation, she was talking about indicia of reliability, trustworthiness, et cetera, of the statements. She never introduced any statements through her witnesses. So, Judge, we'll stand on our objection and the fact that even if the court wanted to side with the state, they hadn't met its burden for any number of reasons.
Your Honor, I apologize. My understanding was to deal with the objection as to whether or not a statement, when I say, what did Anitra tell you? The defense stands up and says, objection, hearsay. Okay? What the statement is not the issue. It's whether or not the statement that's about to be said is hearsay. Okay? So what we have to establish in an 807 is there any other evidence with regards that, that there's a video of this conversation that they can put in and we don't have to have somebody talk about it? Or is there communication through them in another format or another witness that can testify to it that's not hearsay? Okay? But for the purposes of this hearing, and I actually thought it improper to attempt to impeach any of the witnesses because the issue before the court today is the nature of the relationship, about whether or not there's sufficient trustworthiness, a guarantee of trustworthiness because of the nature of the relationship.
Let me stop you right there. The purpose of today was whether or not these statements are admissible under 807, which is why we're doing it outside of the presence of the jury. 807 has 3 prongs. The first prong is the statement is offered as evidence of material fact. The second prong is the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure. And you have not elicited any information about any statements. The only thing you have had the witnesses discuss is how they knew the victim, how long and what kind of relationship they had, and did the victim share information regarding her relationship. I'm concerned on how the court is supposed to rule on these statements when I don't know what these statements are. I can speculate as to what they are, but I don't know. There's not been any statement introduced for me to consider.
Your Honor, I'll put the witnesses back up. My understanding was I needed to establish, for the purposes of 807 and the objection of hearsay, that as to the trustworthiness. I did not want to get into their full testimony at trial.
Well, you're either going to have to put them up or you're going to have to proffer the evidence because Taylor v. State says attorneys or officers of the court in a statement to the court in their place is prima facie true and needs no further verification unless the same is required by the court or the opposite party. I don't have a statement to rule on at this point.
Your Honor, I will do that.
Okay.
With regards to Sierra Stewart, that the state intends to elicit that the party that she was familiar with, DeMarcus, that she had moved out of the home that she shared with the victim prior to the onset of their relationship, that she did communicate with Anitra, and that Anitra expressed concerns to her about the fact that their relationship was very toxic, that it went back and forth, that they would be happy one day and miserable the next, that they were fighting shortly after they began dating, that they would this is not only her statements made by Anitra, but her observations, that Anitra would tell her that she was trying to break up with him, that he would not let her go, that he would show up at her home unexpected and uninvited, that when they would fight, he would call her incessantly, that she was actually witness to DeMarcus calling her phone dozens of calls in a short period of time, and eventually hearing Anitra pick up the phone and screaming, "What do you want? Leave me alone." That she was present at a time when she was on FaceTime with Anitra. During the course of their friendship, that Anitra would describe the defendant talking down to her. That he would talk to her, tell her that she had certain kind of timelines to get in by.
Right. Now, let me interrupt you, Ms. Baskins. What I'm interested in is the statements, because Ms. Gunn is not available, what statement she has to offer. If there's something that Ms. Stewart personally observed and witnessed, Certainly, she can testify to that.
Right.
So when you use the pronoun she at this point,
I
I'm
apologize.
getting confused as to whether or not it's Miss Stewart or it's Miss Gunn.
Yes, ma'am.
Okay.
I'll be more careful.
Okay.
That Anitra would tell Sierra that the defendant would tell her whether or not she could drink, who she could hang out with, and would tell Anitra that. That Sierra was aware of Anitra telling her that the defendant wanted her passwords to her social media. That Anitra, this isn't personal observation, that Anitra talked to Sierra about the defendant putting his hands on her. That's the language. That Sierra attempted to counsel her friend to get away from him. That she remembered Anitra talking about a time where the defendant threatened to shoot up a house because the victim, Anitra, was out on a date with another man. And this was around her birthday. And that Anitra had actually showed her the text messages that DeMarcus had sent. That Anitra talked to her about her tires being slashed on 2 separate occasions. That Anitra had to use the money that she had been saving up for a trip to Texas to pay for those tires.
Isn't there other evidence regarding the tires?
Yes, sir.
That Anitra talking to her about using the money about the tires, and the fact that Anitra initially didn't know who did it and then acknowledged later on that it was in fact the defendant. And again, that Anitra talked to her about her windows having a rock thrown through them. That she was not at first sure that it was DeMarcus. That DeMarcus actually even offered to give her a gun to protect her from whoever had assaulted her home on February the 5th. That they spoke several days later, and that Anitra advised her that DeMarcus had confessed to the act. That Anitra didn't particularly like to involve the police. And that's the nature of those conversations with regards to Sierra Street.
All right, the next witness.
As to Ms. Plumber, that, of course, her observations, the court's not addressing that, but that
Any of the witnesses, as you well know, can discuss and testify regarding their.
no, that's actually a physical observation. That Anitra would tell Plumber when they would break up, that she was aware of the verbal arguments that Anitra and the defendant would have, that she recalls Anitra telling her that Little told Anitra, if you leave me, I'll kill you. That he would call her names, and that she wanted to break up with him, and that she had fear of him. And lastly, as to Veronica Taulton, that Veronica Taulton and Ms. Gunn were friends, of course, at work, and they talked about the relationship. That Veronica Taulton will testify to the fact that Anitra told her on multiple occasions that she was breaking up with Mr. DeMarcus Little, that he was controlling and jealous, wouldn't take no for an answer, and that she had fear of him. just one second, I'm making sure I have all my notes, so I want to make sure. Yeah, that's it. Those are my statements at the time.
All right, Mr. Davis, in response.
Yes, Judge, so we'd have to do some unpacking with regard to what the state has said, because sort of that blending in the court's ruling with regards to prior difficulties with statements they're claiming under 807. They didn't actually talk about any specific statements. And one of the things that the court said was, is there any other evidence? So to just start with that, there would be other evidence if the court were to allow a statement, because essentially she's saying that all three people are going to say the same thing, with the exception that one witness is supposed to say that DeMarcus Little had claimed to kill his gun. So first, if they're trying to get in under 807, they're going to be redundant to have three people to essentially say the same thing, except for the one statement that my client allegedly said he would kill his gun. Now, as the court well knows, that shouldn't be ruled admissible. I think it would be both hearsay and it would be inflammatory to have a witness to make a statement like that would so inflame the passions of the jury they could vote to convict my client just based upon that statement. So that statement should be excluded, even if we weren't talking about 807. But to get back to 807, when the court asked the state to proffer statements, that was the only statement that I can remember that the state did proffer. The other things that the state talked about were observations, and it's just all kind of blended in there together. Observations and then no actual statement. So an 807 ruling is a ruling on a specific statement, and the state has only proffered, as I can recall, maybe something else the court can recall, one statement that is highly inflammatory and should be essentially not allowed in any case of this sort, just based upon the naked proffer that this was allegedly said to a person. I mean, there's no indication, for example, that it was ever documented, the person told the police. So there is not this trustworthiness and indicia of reliability. The court had an opportunity to listen to some of these witnesses who, if we were just looking at them on the whole, would state as to certain parts of their memory they couldn't recall. And I would ask the court to essentially rule at this point that nothing has changed from the order in which the court entered into, and I'm reading page 3. The court reserves ruling on the admissibility of such testimony from any of the named witnesses, Sierra, Stewart, Ms. Plumber, Ms. Taulton, until such time as the court can determine whether such testimony will be admissible. And I don't think the state has done what the court asked it to do when the court issued the ruling. And as I stated before, Judge, I think the court alluded to 807, and I think the state essentially picked up on that language in your ruling and essentially was trying to ask the court to reconsider the order you issued on the 4th. They filed this notice/motion within seconds of the court's ruling, and then they come into court and they have not met their burden in meeting the specific requirements under 807. Even the court were to look at it as 807, and I think for that reason, them not complying with this court's prior order and under the law not complying with 807, the court should rule it at this point inadmissible. But with regard to the specific statement that my client alleged that he was going to kill his gun, I think it's highly inflammatory. And that's a decision for this jury to make based upon the evidence they present in this case.
All right. Let me take a recess. I'll get y'all in a few minutes.